Hi, everyone. Uh, Larry Backer and Frank Ravitch here, the authors of the Law and Religion casebook, and we are delighted to continue with our series of informal discussions of some of the major cases that are treated in the book. Today, we are going to be talking about what I think is, to some extent, one of our favorite cases. And not necessarily because we love it or we hate it, but it's just an incredibly fun teaching case, is the Everson case. In its early forms early in the book, and rightly so. I love teaching Everson. I can construct, there have been years when I've constructed the entire course around Everson and its pathologies. And there's a lot of meat there. And what I want to do is start with Frank. What do you love most and what do you hate most about Everson?
Well, what I love most about Everson is first of all, the incorporation discussion, which sometimes, frequently gets overlooked a bit, right? Which is,
I'm going to hold you to that because I'm going to go there and I'm going to press you on that one.
Yeah, I find that to be a really, it's interesting, because it was an open question before Everson, right? Is the Establishment Clause incorporated? So, one of my favorite parts of Everson is that incorporation discussion. Of course, all 9 justices agree in Everson that incorporation was correct. Obviously,
good thing Justice Thomas wasn't on the court then.
Yeah, Justice Thomas definitely. We'll talk about that in some later cases, I'm sure, like Zellman and things like that. Justice Thomas has written, numerous concurring opinions, sort of suggesting maybe we shouldn't have incorporated the.
And that's where I was going to press you.
Yeah, I actually think he's wrong about that, but the reasons are very, very complex. And Everson is more of a very kind of a, it brings in incorporation at a time when it really wasn't super controversial from a judicial standpoint, right? It's a 9-0 on incorporation. Right. And so to me, that is by itself just fascinating because it's something that we don't always, it's just kind of quick in the case, but it's this, really core point.
But interestingly enough, it's not only quick there, it's quick in the cases that they cite. So there's this string of cases you go back, and sometimes I make my students actually go back. So they cite one case, that case cites another 1 or 2, and I make them all go back and say, okay, so where is the mother lode of explanation for incorporation? And the answer seems to be in the ether.
Yeah, and that one of the issues with the sort of the step-by-step incorporation that we do is that, you get the opinions, where Justice Black talks about, incorporation and in the 14th Amendment context more generally. But yeah, when you're looking at a specific clause, it seems like the court's getting it right, that they're incorporating, obviously the free speech and free exercise. And I would agree the Establishment Clause, although I understand the controversy around that, and I'm sure we'll continue to address that. But yeah, there is sort of a want of meat there, I think is the best way to put it.
And here's my Thayer moment. You remember old Justice Thayer? And what I challenge my students with, I go, normatively, you all love incorporation because now from a political social perspective, we've all embraced it. But let me be the devil's advocate as a religion class. So I'm going to use some guardian spirit from the underworld who's not nice and say, maybe the court overreached itself. And while we really love the idea of incorporation, that really is something that ought to have been at least taken 5 minutes to consider whether it was beyond the court's power, and indeed something that the polity through its elected branches, is given the system that the Constitution provides, ought to have been quite explicit, and that they never did, suggests something about the nature of social political power through interpretive legalization in the United States that belies the system of constitutional amendment, but that also then weakens the authority of these judicial pronouncements precisely because they're judicial and they are not textual.
Yeah, and I think that's, without more explanation as to why, the Establishment Clause is different. And so, it is not as clearly an individual right. And you get people, for example, Dan Konkel's written very persuasively about, the idea of it being a structural provision, as have a number of other great scholars have written about that. And so, it's what's interesting about it is that the Establishment Clause, if any clause, should have had a lot more discussion for the reasons that you're talking about, right? I mean, textually speaking, it's not as clear. It's not clear it shouldn't be incorporated. My argument.
Yeah, no, agreed. Yeah. The question isn't what its relationship ought to be with respect to states, the fundamental, but it's an important principle question is how you get there.
Well, and that's the thing, because to me, in some ways, the states were more of a risk to fundamental freedoms in the Establishment Clause area. We've seen that with cases where, you've got local and state entities acting in a way that is not only promoting religion, but it's promoting religion in a way that is discriminatory, or at the very least, sort of lowering the level of citizenship of religious minorities and dissenters.
Which is precisely what the founders were more than happy with at the time of the founding of the Union. Now, notice I didn't say republic or the nation, I said the Union. And then that takes us back, of course, to the transformative, how volcanic was the 14th Amendment. They took it for granted. Well, okay, it's no longer a union, it's now a republic. It's no longer a collection of autonomous states. It's now a nation. And we're going to use this 14th Amendment as this magical fetish that from out of which the judiciary will, without the president or Congress interfering over much, craft the legalizing structures of nationality. And it's worked. I'm not quite sure that, and it was done very elegantly, but it's worth it for me to raise with the students the question of, is this really what it was meant to be at a time, certainly in the 1790s and early 19th century, when the idea of having a state religion was not something that would have caused the predecessors of the New York Times to have collective apoplexy and be hospitalized.
Yeah, I also focus quite a bit on this in class, and some of the things to look at also within the 14th Amendment. There's another question that's occurring there, which is the Due Process Clause the best place to be bringing this through, right? I mean, the Establishment Clause could theoretically, when you look at what some states were doing at the time, and the impact that it was having on religious minorities and dissenters, the Privileges and Immunities Clause, which you could talk about in many contexts, would have been if the court had not sucked the power out of the Privileges and Immunities Clause, right? The Privileges and Immunities Clause would have been a much better place through which to incorporate.
Agreed. And frankly, and that for me is the Achilles heel. And we get there in class, and then I say, but look, as easy as it was for the court, well, maybe not politically easy, but at least theoretically, as easy as it was for them to suck the life out of privileges and immunities, they could, by the same process, blow life back into it. I said, but now you've got a problem. Because if that's in fact what we're doing, we're treating the interpretation of the Constitution as some kind of accordion, these clauses, then what kind of protection? The whole point of a textualist approach to fundamental organizing principles of the state was just that. And yet we've all decided collectively, including me, I mean, we're all part of this group, and certainly since since 1865, then indeed we're more than happy to live in a textual accordion system than we are by relying much more definitively on text. And and having said that, of course, text is as fungible as everything else, and you can make all kinds of arguments. But it's interesting. But
yeah, that's one of the things I think is when you look at the text of the Establishment Clause, because that's sort of something that the Establishment Clause itself runs throughout Everson, not just on incorporation. It is, I think, an intentionally pretty vague clause once you get past Congress, right? And after the 14th Amendment, once we incorporate it, then sort of Congress, in a way, as a practical matter, drops out, and you can just say government. And because after incorporation. But textually speaking, the Establishment Clause, I've seen some fascinating textual arguments on both sides of what the Establishment Clause means. And it's the same thing with originalism on the Establishment Clause. One of the things that concerns me is I've seen equally persuasive arguments on both sides or different sides for the text and the original intent of the Establishment Clause, which all that means to me is that if judges are making decisions claiming that they're basing it on text or original, experience, knowledge, however, whatever brand of originalism they're using, then it's obviously based on something else.
Right.
Because
the same applies to the living constitution, folks. The Rousseau issue. In all of these cases, they're either guessing, they're reducing or essentializing, and then transmitting to the, and for all the good reasons and without evil intent, but they're still doing this. But for me, I view this as quite exciting, because what it really suggests is that when you're looking at these issues, and this is sort of the way I teach the course, what you're really trying to focus the students on is what constitutes, given all of this, what constitutes the range of plausible outcomes that you could have had, and then to focus students on the fact that that range can actually lead you to very inconsistent results, and yet they are plausible. And then, well, where does that lead us? Does that lead us to politics? Does it lead us to the way in which the normative discussions on the court reflect normative fractures within society? What does that tell us about the utility of the document in managing these kinds of things, et cetera, et cetera? So for me, it's great. But I want to get us to, it's love and hate, but I want to get us to that fake wall of separation, or put a different way, the chain link fence that the Everson court constructed. They call it a wall of separation. You think of a brick wall. I tell my students, it's a chain link fence, and there's a whole lot of space.
I actually draw the wall on the board with the city bus from Ewing Township on one side of the wall, and by the time we're done doing the case, I say, well, there's really only two ways that scholars have determined that this could have happened. One is that there's actually, the court was able to create a wormhole that allowed the bus to go through the wall. The other is that the court was actually somewhat full of malarkey. I use more direct words, and that actually, while the wall might have been, and all 9 justices agreed that it should be quote unquote high and impregnable, the problem is somehow you do get the city bus fare and the city bus through it. So perhaps even from the start, it was not viewed as an impregnable wall, even if maybe they thought of it as a high wall.
Yeah. It's a big old chain link fence with a bunch of gates on it. But
I refer to it today after Zellman in cases like that it's now just a crumbling pile of rubble, because Zellman essentially, I mean, to me, Zellman is one of the most activist cases in modern American history, because it just, I mean, it doesn't really even pretend, well, it does pretend to be following Everson and Witters and so all these cases that we'll talk about later in later recordings. but it shows what happened to this great supposed wall. But since there was already a hole for a bus in it, maybe it made it easier to crumble.
But they're even in that case, even they were at least up front. And certainly from Rehnquist's time on, there was a willingness and from my perspective, a bit of courage to actually go out on text and say, look, we don't buy this wall idea. It was not particularly coherent to begin with. We've made a mess of things since then. Now, whether you agree with what they're saying or not, still it's interesting for them even back then to say, hey, and so maybe what we should be doing, we can't fight it directly, but we're going to take that bus, we're going to wormhole our way or go over.
Yeah, I would say though, and that to the point that it goes is correct, that they are openly acknowledging that the concept didn't work. The problem is they go from there to intellectual dishonesty in the Rehnquist court and now sometimes with the Roberts court, where they pretend they're following 50, 60, 70 years of precedent. They say they're still following this case or that case or another case, and yet they're really completely changing the way things are, and they're not explaining why
exactly
they're
right. No.
And so to me, it's I don't think any rigid concept can work in such a nuanced area as law and religion, where the gray is everything.
No, and I agree with you. And it highlights something that our students pick up much earlier than we do, and that is our students are actually quite astute. They start reading this, and by the time we get to Zellman, they start asking, well, then what do these cases mean? Because I just read 5 or 6 years ago, the case means this is how you read it. Now they're taking this and they're doing this. The circumlocutions are such that either they reduce these cases to rhetorical gibberish, or they use them, and this is what we do sometimes in talking about this, they use them as fetishes, which are then invoked in particular ways to get them to, in the ceremonial of the opinion, to get them to where they were going to go, despite or because of those cases. And
yeah, we talked about that in our first video on Fulton, and yeah, I think that's really exactly right. My students really almost exactly the same question. How do they do this in Zellman without overturning Everson and Lemon? Right. I mean, at least you could find, we'll talk in a second about the quote unquote neutrality concept in Everson. Maybe you could theoretically use that somehow for Zellman, but there's lots of problems. And for those of you who don't know, Zellman is a case you're going to look at in chapter 4 that deals with school vouchers. So right. For students who are watching this, it's a case that really doesn't follow a lot of precedent.
Oh my God! Yeah, no, and you got me there. You got me there. Famous. What was footnote 2 and 3 of the Everson case? Oh yeah, the statute is about reimbursing kids who are going to Catholic school. Definitely not kids who are going to for-profit. Apparently, this is some kind of less desirable, and how life changes between the 40s and this century. Less desirable, much less Baptist, Muslim or Jewish schools, but that's okay, even though the statute discriminates on its face, because the only people who are getting reimbursed besides public school kids are Catholic kids. No problem. Let's go and build this extraordinary rhetorical forest. Almost.
Well, that's kind of what's behind me, because when you get to
there's no neutrality.
Justice Jackson's dissent calls the majority on, right? The majority reads the New Jersey law or the Ewing Township rule in Everson, and the majority says, well, it's open to everyone, right? It's open to anybody who would want to take part in it. The bus fare, right? The bus fare is available to everyone. And then when we get to Justice Jackson's dissenting opinion, we see, well, actually, literally on its face, it does not. And then there's a backstory there that a lot of people don't know, which is that we have a tendency to look at Everson through our modern lens of culture war. And what was really going on in Ewing Township wasn't that they were necessarily wanting to discriminate in favor of Catholic schools. It's just the Catholic schools asked. And so they said, yeah, you know, we'll do this for you. And there were actually, apparently they did approach, there was one, I think, Jewish school and a couple of Protestant schools, and a couple then of, you know, non-sectarian private schools. But the other schools were worried that it would violate the concept of separation of church and state, which was already in common parlance, or they were worried that it would violate the law. Maybe even New Jersey constitutional law may have been what they were worried about. But at any rate, they didn't want to take part in it. So that's kind of an interesting little backstory there. But we tend to look at, well, Ewing was trying to favor this group. And actually, it was just kind of, well, that's who asked.
Right, right. No, exactly.
On its face, it was only the Catholic schools.
Right, right. And for the justices, of course, their failure to confront that, because that would have been the easy way around it, right? Yeah. Instead of saying, well, look, there are a lot of other schools, they might have been, it might have been available to them or not, or they could have said, look, the concept's okay, but the law is going to have to be revised because when we say neutral, we mean neutral, and the law is not neutral, and you're writing a law. This isn't a set of social rules, so get it right. All of those opportunities were kind of missed, and then create, well, in this case, not difficulty, because in typical American fashion, we start with text. We start with, even if you're a textualist, right? We start with text. We then invest it with meaning. In this case, we strip the text of its meaning, public school plus Catholic school kids, and then having rewritten it by interpreting it in a particular way, boom, then we go forward and we create a jurisprudence, leaving in its wake the text, which remains unchanged, even though now supposedly or purportedly it's been changed by this jurisprudence or this jurisprudential gloss.
Yeah, and going back to your first question, this is what I like least about this case, right? I like the incorporation, the fact that it did incorporate, although as we talked about, that itself is problematic. But this is one of the things that I think is at least I dislike the most about this case, right? You can't escape the fact that whether it was with evil motive or not, clearly was not with this intent to discriminate against others, but as Justice Jackson points out, the text was what it was: Catholic schools, public schools. And even if they would have included other schools, by the time the text was written for this rule for bus fare, it was just that. And so there's no way that this meets the concept of neutrality, which the court in this case equates with strict separation, right? The court throws around the term neutrality and it throws around the term separation, but it never really it defines separation to some extent, but it doesn't define neutrality. And as we saw in courts between this court and Lemon in the 1970s, neutrality in this case was understood to mean separation, which, I mean, that's problematic because it's, in a way, it's not neutral. The current court's version of separation, which favors religion, is not neutral. This version, which could disfavor religion, is really not neutral. And yet this term this is the first time we see this term neutrality thrown around, and it's already problematic. In its first incarnation, it's already problematic.
And now you raised, thank you. You opened the door I was hoping you're going to open. All right, so here's a provocative question. And I tease my students with this as well. Reading Everson, isn't Everson really a dry run for Lemon? It's all, the entirety of the Lemon test is extractable from Everson itself. Neutrality, secular purpose, and no entanglement.
You know, this is a hard one for me. Whether, obviously you can easily see that Lemon, the first two prongs trace back to Abington Township v. Shep textually, right? And then and then the entanglement, to Walls v. Tax Commissioners textually, but both of those cases refer back to Everson.
Right, normatively.
And I agree that you can, I guess what I would say is you can see the seeds of all of those things planted in Everson, but it's unclear how they're going to grow at that time, right? So at the time of Everson, I think you could definitely see something like Lemon growing out of it. With that said, it's still not 100% clear because the court in Everson kind of says one thing, but then does another, right? Whereas in Lemon, the court says one thing and does it, right? So, so that can be a little confusing with where it's going to go. But I do agree with you. I mean, I think certainly the quote unquote neutrality discussion in Lemon is definitely directly going back to Everson and this concept of separation as neutrality, which of course, again, is just as problematic as today's court's version, which is basically favoring religion in a case like Zellman as neutrality. But you know, in terms of specifically things like entanglement, I think the seeds are there in Everson.
Remember, they didn't provide, all they're doing is reimbursing, right? And so you can see, oh, well, it's not like they're doing anything else. You're just getting your money back. Oh, what are you going to get? You're getting a reimbursement. Oh, reimbursement. All of a sudden, you're starting to get the genesis of everything from reimbursement for all kinds of things to disentanglement, because there's nothing going on other than to effectively give the parents choice that is then subsidized.
Yeah, I think that's, I mean, I think that you literally just did a great job of taking us from the seed that was in Everson to how it went in Lemon. And I think, you know, when you look at like the voucher case, Zellman, you know, it goes back to Everson and says, well, the neutrality in Everson combined with the fact that it was just reimbursement allows us to give full out vouchers for tuition when over 96% of it goes to religious schools. You know, I don't think either the Everson court or the Lemon court would have ever conceived of that, let alone even the Agostini court later on. What's interesting is you know, as you point out, I do think the Everson court could have very easily seen Lemon coming, right? You know, but I do think it could have gone other ways as well from Everson. But it, yeah, I think you did I think the way you explained it's great. You take from the seed to entanglement and Lemon.
Right, but then you have the wormhole, which I love that concept. I'm going to steal it from you now.
I use that, and the other one I use is as Diagon Alley that Justice Black knew Albus Dumbledore from Hogwarts and had him open up Diagon Alley so that the bus could get through.
That's right, and it gets through all the way to Zellman. All right, last question, because we are really well out of time. And thank you all for being patient with us. We swore we weren't going to do more than 20-25 minutes, and here we are again.
We just love this stuff. So we hope you are loving this as much as we do. Just studying law and religion. Anyway, go ahead.
You cannot leave Everson, even just very briefly, without at least a nod in the direction of that extraordinary rhetorical flight. So any words on that? I love that. I love taking the students through the renditions of this rhetorical flight that gets us to the wall before it gets before they drill holes through it or introduce us to the wormhole. What do you think?
You know, it's interesting because, you know, we go through all the history and you know, that this was the intent, and this is, you know, that it's clear that the intent was a high and impregnable wall. And, you know, talking about Jefferson and Madison, and you get Justice Rutledge's dissent, an even deeper version of that. Right. And, you know, for me, it all comes down to, that is one, but only one of several potentially justifiable views of the intent or the history there. As you know, I've written quite a bit about both this court's historical originalist sort of flourishes, as well as the Rehnquist court's historical originalist flourishes, and the fact that they both have a lot to back them up, which suggests that neither of them are making their decisions based on that if they're really honestly looking at the history and the intent. So the flourish, it really is. I mean, I like the fact that you called it a rhetorical flourish, because I mean, certainly every text that they cite in that section is there. It says what they say it says. Whether that was the intent or the meaning is another question. But there's also stuff that, you know, they're not citing, that, you know, and same thing when people go the other way in originals. I don't think, you know, and I'll be open here, I don't think originalism is particularly helpful when it comes to the Establishment Clause, because it's covering up what's being done on other grounds. But I like the way you use the term rhetorical flourish, because one theme you see throughout that discussion, and you see it in the dissents as well, is what I think this case is really about, which is a court that is existing in a period of recognition of pluralism, and recognition that discrimination against, in this case, potentially religious minorities exists out in the world, or that favoring religion might create rifts or problems in religious pluralism in a religiously pluralistic society. And I think that if you look at a lot of the flourishes and a lot of the things that they cite, I think what it's doing is, I mean, they're basing it on original intent, which is an acceptable, I guess, judicial tool, but so is the opposite when the Rehnquist court does it, right? So, you know, I think that the flourish, like, again, rhetorical flourish, is also in a way giving us a clue. Well, maybe this is about pluralism. Maybe this is about a court trying to grapple with the implications of establishments and how they may play out in an increasingly religiously pluralistic society that maybe the framers could have never envisioned.
Right, and that brings us back, to incorporation again, and the fundamental issues of text and judge, polity, and elected officials. And with that, we are out of time. We can go on for another 3 hours on this case. We hope that you have enjoyed at least a little peek into our thinking. We're going to grapple more with the pros and cons of original understanding and original intent. I'm more of a fan, or I will at least play more of a fan than Frank, and that will liven things up as we move and look at the next set of cases. Anyway, I hope you've enjoyed this. Thank you very much, Frank. As always, I learn much more from these sessions than I can imagine. And I hope that you all have found this enriching and useful as well.
Yeah, so me too. I always learn a ton doing these, and it's just always a pleasure to see you, Larry, and to have our readers be able to have access to this is just wonderful. And thank you all, everybody out there, for caring about law and religion. You know, the beauty to it is we have such a rich area here, and it's still an area where people can agree and disagree and really think and enjoy it, really enjoy that dialogue. And so it's great. And I'm pleased that I was able to talk to Larry about this, and that you all get the benefit of Larry's wisdom.
Oh, and yours. All right, folks, until next time.